We shall overcome someday. Seven will die. Seven will die someday. Deep in my heart, I do believe seven will die someday. Free Machete, free Bobby Young, free Bobby Young, free Dr. Kiiza, free Obedi Utare, stop Nicaragua. Enough is enough. Free Council Eron. Free Council Eron. Free Council Eron. Freedom for Council Eron. Freedom for Council Eron. Freedom. Just let them know.
Mr. Eron Kiiza in prison. We can't really have filed this matter without the Attorney General's involvement. Wouldn't want to come and then they say, but why did you serve Attorney General? Why did you, who will speak for the prison authorities and so on? So the matter, my lord, is properly before you.
The facts of the case. Johnson Atwera, I'm a senior state attorney. The facts of this case is that my brother, Mr. Eron Kiiza, an advocate of High Court and all courts of judicature in Uganda, was accused of contempt of court in the General Court Martial.
Which court is no longer in existence?
Not at all, my lord. It is in existence. The Supreme Court did say that the General Court Martial is a court of law under the Constitution of Uganda.
And that's the point I want.
Yes, it did not abolish it. It affirmed its existence, but only limited it to specific cases of offenses relating to medical service.
How about the way it was constituted?
It gave, the Supreme Court gave advisory on how best it can be constituted, but it did not give orders. Yes, my lord. So Mr. Kiiza Eron was accused of contempt and was tried and sentenced in accordance to Section 169.
What is the sentence under the law?
That's why I'm coming to, my lord. Under Section 169, 1G, it relates to contempt of an advocate. And when you read it in relation to Section 2129 of UPDF Act, it says it gives an advocate who is charged of contempt before the military court of a maximum sentence of 5 years. The sections exist, not at all. Maximum 5 years. I want to believe that the 1G and 2129 of the UPDF Act to Section 169(2), which is general in application, that gives 30 days. But Kiiza Eron, being an advocate, it puts him under a specific provision of 169 G, 1G, and 2129. That gives a maximum sentence of 5 years.
So you are saying actually the court was lenient?
Absolutely. Actually, the court martial was lenient, considered his
You stick to that in your
Absolutely.
reply and advocate?
Yes, my lord. My lord, I want to refer to Order 3 of the Supreme Court decision number 2 of 2021, Honorable Kabazibuka, Attorney General versus Honorable Kabazibuka. It said that this judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentences.
Remove the word save and put except. Except.
To make it easier, except where the conviction and sentences are being challenged in courts of law.
So, is it your view that the conviction and sentence of the person in court
Were affirmed by the Supreme Court that they carry legal basis and are effective?
They are effective for as long as they have not been challenged?
Yes. And even the challenging, the Supreme Court did not dispose of the challenging. It says it did not, it means that where the challenge is ongoing, the trial can continue and be challenged.
So for me, what I'm raising at this point is this decision properly challenged before me, or it
My
should
Lord.
have been challenged somewhere.
My Lord, Mr. Kiiza did file a notice of appeal. And when he filed a notice of appeal,
Before which court?
the General Court, the Appeals Tribunal of the General Court Martial. In essence, the fact that all files were transferred to the ordinary courts, the right forum, my lord, would be the criminal division. And indeed, with due respect to my colleagues, there is no way you can appeal or apply a conviction of a criminal matter against Attorney General. That was in error on their behalf. By the wording of Article 119 that establishes the Office of the Attorney General and its functions, we are only liable to only civil wrongs against government. This matter arises from a conviction, it arises from a matter which is criminal in nature, and the right forum would have been the criminal division.
So who would have been the respondent if not the aid?
Uganda, the state of Uganda.
Represented by who?
Uganda would have gotten its representative.
I some screams. Very difficult. Who is starting with? He is okay?
Well, today we came to receive the ruling on the various applications that have been filed to seek the freedom of counsel Eron Kiiza. First of all, the judge then first said that today was not the date for the ruling, and he stepped out. When he came back, Mr. Eron Kiiza had been brought by the prison authorities. Eventually, we ended up before the judge. The judge then asked whether we had complied with the service and filing of affidavits and written submissions, which on our part we confirmed. The state attorney claimed that he had not received some of the submissions. But then he said that in any event, the various applications all seek the same remedy, and apparently that whatever he had filed is enough to dispose of all the applications. The judge then asked us to summarize the gist of the argument, which we did. It's a very simple argument that all convictions and sentences by general court martial in respect of civilians like Eron Kiiza, which were challenged, and in the case of Kiiza by an appeal, were nullified by the Supreme Court. So we asked the judge to restore Eron Kiiza's freedom by ordering for his immediate and unconditional release. The judge and the state attorney at some point were of the view that this matter should go to the criminal division, the High Court. And our reply was simple. The matter we had brought before the judge was not a criminal appeal, it was not a criminal revision, it was not to interrogate the sections under which Eron Kiiza had been convicted and sentenced, but rather a matter to enforce the right of Eron Kiiza to his freedom, a freedom that the Supreme Court had in its ruling in the Kazukuka case declared. So the judge has said Monday 2 o'clock to give his ruling. We hope that this time round it will be ready. It's unfortunate that this straightforward matter is taking us another 1 more week. No, there's no lawful sentence. Once the sentence is appealed, the judgment of the Supreme Court had the retrospective effect of nullifying that sentence. The word retrospective is a simple English word which we believe that everybody understands. Something retrospective is that it works backwards. Okay? So, the effect of the judgment of the Supreme Court was to work backwards and nullify the conviction and sentence of Eron Kiiza. And the simple thing we ask the judge is, can you make that order to release a lawyer who is in effect legal detention now? Fena tubadde tulowooza nti omulamu Kiiza naye tekisobose omulamuzi ne Ssetatone balabise ng'empapula ezimu ze twateeka ku kooti banaziyitamu bulungi. Omulamuzi n'atusaba tumunyonyole mu bufunze nsonga ki gye tuleeta mu maaso ge. Tumunyonyola mu musango gwa Kabazikuka, kooti yasalawo omuntu yenna atali muserikale eyasingizibwa emisango n'asalirwa naye n'ajulira nti emisango egyo kooti yagimenyawo. N'olwekyo teri nsonga mu mateeka lwaki Eron Kiiza akyali ekitale okukomera, era ne tumusaba amuyimbire. Omulamuzi atuwadde olw'embalaza olujja 8:00 w'ensala ye okusuubira nti olwo kanso Eron Kiiza anaddizibwa eddembe. Ekyo n'okibuuza mulamuzi kubanga ekimu kyabadde alowooza nti si yandibadde mu mitambo gy'omusango guno tubatugenze criminal division, naye tumumuwabudde nti Eron Kiiza tazze kujulira, tazze kwemulugunya kawaayi lukiiko tumasho gwe yakozesa okumusalira, azize kutegeeza kooti Supreme Court yasazaamu ebyo byonna ebyakolebwa. N'olwekyo ab'enkomera tebalina tteeka so tekyetaagisa kumutwala mu criminal division kubanga tagenda kwewozaako, takyalina kyakwewozaako. So tusuubira nti omulamuzi obalira kitegedde bulungi, asuubire nti anaatuwa ensala gye tusuubira nalabagana ku mwanya.